Judiciary in India. The parliamentary system of government in India has three organs: the legislature, the executive, and the judiciary. The legislature frames the laws and the executive implements them. The judiciary ensures that people adhere to the laws, and if there is a dispute, it is resolved according to the laws of the country. The judiciary also protects the rights of the people. We have studied that rule of law is one of the basic features of our democracy. The success of the rule of law depends on the independence of the judiciary. Every person can only be treated equally in the eyes of the law if the custodian of the law, that is the judiciary, can take independent decisions according to the laws of the country and is not intimidated or influenced by the other organs of the government. What do we mean by independent judiciary? Let us find out. Independent judiciary. Independence of judiciary means that the executive and legislature cannot influence the functioning and the decisions of the judiciary. The Constitution has ensured the independence of the judiciary through a number of measures. The judges do not belong to any political party. A person must be a lawyer to become a judge. He or she also has to have certain basic qualifications. His or her political affiliations are not important for his or her selection as a judge. The position of a judge is permanent. Once he or she is appointed, he or she holds the position till retirement. He or she cannot be removed arbitrarily. So, a judge is able to work in a peaceful manner for a long period of time. However, if he or she misuses his or her power, the parliament can remove him or her through a procedure called impeachment. The judiciary is not financially dependent on either the executive or the legislature. Neither the legislature nor the executive decides the remuneration of the judges. Network of courts. The judiciary works at different levels. At each level, there is a network of courts. If a person is held guilty by a lower court of the country, after a trial, he or she has the right to appeal to a higher court if he or she feels that he or she has not got justice. This way, a case can move from a lower court to the highest court, the Supreme Court. Supreme Court. The Supreme Court is the guardian of the Constitution and the highest court of appeal. The jurisdiction, functions and responsibilities of the Supreme Court are defined by the Constitution. Composition. The head of the Supreme Court is the Chief Justice, who is appointed by the President of India. Another 25 judges work with him. They are also appointed by the President in consultation with the Chief Justice. Qualifications. To become a judge of the Supreme Court, a person needs to have the following qualifications. He or she must be a citizen of India. He or she must have at least 10 years' experience as an advocate or 5 years' experience as High Court judge. He or she may have been a member of distinguished juries. Tenure. The judges of the Supreme Court retire at the age of 65. If they misuse their power, they can be removed by Parliament by a process called impeachment. Powers of the Supreme Court. The Supreme Court has a wide range of functions. Its powers can be broadly categorized as original jurisdiction, appellate jurisdiction, advisory jurisdiction, supervisory jurisdiction, court of record. Original jurisdiction. Some cases can only be heard by the Supreme Court. These cases cannot be initiated in any other court. The Supreme Court holds original jurisdiction over such cases. Such cases deal with disputes between the Government of India on one side and one or more states on the other. Disputes between two or more states. Disputes regarding enforcement of the fundamental rights. Cases under public interest litigation, PIL. Appellate jurisdiction. In India, if a person is not happy with the verdict of a lower court regarding constitutional, civil or criminal cases, he or she can appeal against it to the higher court. So, cases can travel from lower courts to the higher court and then to the Supreme Court. The Supreme Court is the final court of appeal. Advisory jurisdiction. The Supreme Court has a special advisory capacity. Sometimes the President might seek the advice of the Supreme Court on matters which involve the public or those which require interpretation of the Constitution. However, the President is not bound to accept the recommendations of the Supreme Court. Supervisory jurisdiction. The Supreme Court oversees and supervises the functioning of the lower courts. Court of Record. The verdicts and judgments made by the Supreme Court are kept as records for reference and use by lawyers. High Courts. High courts are the highest courts at the state level. They function under the supervision of the Supreme Court. Like the Supreme Court, the high courts also exercise different kinds of jurisdictions. These include original, appellate, and supervisory jurisdictions. A high court exercises original jurisdiction in cases which involve protection of fundamental rights, disputes related to state elections, and cases where interpretation of the Constitution is needed. It acts as a court of appeal for the subordinate courts. If a person is unhappy with the verdict of a subordinate court, he or she appeals to the High Court against the verdict. The High Court also supervises the functions of the subordinate courts. There are 21 High Courts in India. Some High Courts are common for 2 or more states. Punjab and Haryana share a common High Court in Chandigarh. There is a common High Court at Guwahati for the 7 northeastern states of Assam, Manipur, Meghalaya, Nagaland, Tripura, Mizoram, and Arunachal Pradesh. Composition. A Chief Justice heads the High Court. He or she is appointed by the President in consultation with the Chief Justice of India and the Governor of the state. The number of other judges depends on the size of the state. The bigger states will have more number of judges. They are appointed by the President in consultation with the Chief Justice of India, Governor of the states, and the Chief Justice of the concerned High Court. Qualification. To be eligible to be a judge of the High Court, a person must be a citizen of India and a High Court advocate for at least 10 years, or holder of a judicial office in India for at least 10 years. Tenure. A High Court judge holds office till the age of 62 years. If he or she misuses power, he or she can also be removed by the President by the process of impeachment. Subordinate courts. There are courts at the district level that are subordinate to the High Court of the state. The court of the district and the sessions judge is the highest court in a district. When a judge of this court hears civil cases, he or she is called the district judge. When he or she hears criminal cases, he or she is known as the sessions judge. So the same court acts as both the district court or sessions court. The district or sessions judge of this court is appointed by the governor of the state after consulting the Chief Justice of the state High Court. Revenue courts. Revenue courts are those that hear cases which involve the payment of revenue. The highest revenue court in a state is the Board of Revenue. The highest revenue court in a district is the Court of the Collector. Appeals from this court are heard in the state High Court. Nyaya Panchayats. Nyaya Panchayats serve as village-level courts that settle minor cases of theft and quarrel. They are a part of the Panchayati Raj institution. There is usually one Nyaya Panchayat for a group of villages. The members are elected by the Gram Panchayat. Appeal from the Nyaya Panchayat is heard at the district courts. Lok Adalats. India has had a long history of resolving disputes through the intervention of village elders. Lok Adalats are people's courts based on Gandhian principles, which follow very simple procedures to settle petty disputes through conciliation and compromise. These courts are organized from time to time to give speedy justice at a low cost, as there is no court fee. Lok Adalats are presided over by a sitting or retired judicial officer, with 2 other members, usually a lawyer and a social worker. Some types of cases the Lok Adalats deal with are motor vehicle accident cases, where the injured has applied for compensation. Land acquisition cases, where applications have been made to the government claiming compensation. cases for or against local bodies such as municipalities and electricity boards, cases involving commercial banks, matrimonial or maintenance cases, cases of consumer grievances, civil cases and criminal cases. Court cases can be of two kinds, civil and criminal. Civil cases deal with matters such as property, marriage, inheritance, and money. Criminal cases deal with cases of theft, murder, dacoity, or physical injury. Criminal cases must first be filed with the police as a formal complaint. Initially, a criminal case is heard in the court of a judicial magistrate. If the accused is pronounced guilty, he or she may appeal to the court of the sessions judge. If the sessions judge does not modify the decision, the accused can appeal to the state high court. If the accused is found guilty in the high court, he or she can appeal to the highest court in the country, the Supreme Court. A person sentenced to death by the Supreme Court can appeal to the President for mercy. Civil cases begin in the court of the munsif or sub-judge. Cases of appeal move from there to the district court, then to the state high court, and finally